We're back on defendants present represented by counsel. Court has the charge. Let's go ahead and get the panel.
All rise for the jury.
All right, welcome back, ladies and gentlemen. You are considering the case of the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. Now that the evidence and the arguments of counsel have been submitted to you, it becomes my duty to give you the final instructions of the court as to the law applicable in this case. As I told you at the outset, it is my duty and responsibility to ascertain the law applicable to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to ascertain the facts of the case from all the evidence presented. Then, you must apply the law I give you in the charge to the facts as you find them to be. It is your duty to follow the law as stated in the instructions I have given you and am about to give you. You should not single out one instruction alone, but must consider all the instructions as a whole. You have a sworn duty to decide this case based upon the law given you by the court and upon the evidence submitted during the trial. The defendants, Travis McMichael, Gregory McMichael, and William R. Bryan, in this case, have been indicted each individually and as parties concerned in the commission of a crime by the grand jury of this county for the offenses of malice murder, felony murder, 4 counts, aggravated assault, 2 counts, false imprisonment, and criminal attempt to commit a felony. The indictment was returned into court on June 24th of 2020. You will have the indictment with you at the end of the case, and you should consult it for the specific allegations brought by the state. The defendants have each entered a plea of not guilty to the indictment. The indictment and the pleas form the issues that you are to decide. Neither the indictment nor the pleas of not guilty should be considered as evidence. The defendants are charged in the indictment with crimes that are violations of certain laws of the state of Georgia. I want to emphasize to you that the indictment, including all of the counts therein, and the pleas of not guilty, are the legal procedures by which these criminal charges are brought against each defendant. The charges in the plea of not guilty are not evidence of guilt, and you should not consider them as evidence or implication of guilt of any crime whatsoever. The defendants are presumed innocent until each is proven guilty. Each defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given arising from a consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. There is no burden of proof upon the defendants whatsoever, and the burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is upon the state to negate or disprove it beyond a reasonable doubt. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another. You, the jury, must determine whether the state has proven the guilt of each defendant beyond a reasonable doubt as to each count. If, after giving consideration to all of the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit that defendant. But if that doubt does not exist in your minds about the guilt of the accused, then you will be authorized to convict that defendant. If the state fails to prove a defendant's guilt beyond a reasonable doubt, it would be your duty to acquit that defendant. Facts and circumstances that merely place upon a defendant a grave suspicion of the crime or crimes charged, or that merely raise a speculation or conjecture of a defendant's guilt, are not sufficient to authorize a conviction of a defendant. Now, your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses or the equivalent, such as depositions, any exhibits admitted during the trial, and stipulations of the attorneys. As I've previously charged you, a stipulation is an agreement between the parties concerning some fact or facts which you, as the jury, are bound to accept as facts during your deliberations. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial, or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Whether dependent upon direct evidence or circumstantial evidence, or both, the true test is whether there is sufficient evidence, or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Now, testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. Now, the jury must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, the witness's manner of testifying, the witness's means and opportunity of knowing the facts about which they testify, the nature of the facts about which the witnesses testify, the probability or improbability of their testimony, the witness's interest or lack of interest in the outcome of the case, the witness's personal credibility insofar as it may have been shown in your presence and by the evidence, any evidence of bias for or against a party, any possible motive in testifying, if shown by the evidence. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters, and whether a witness has been impeached. The question whether a witness has been impeached is whether you, the jury, believe the witness has been proved unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Now, the defendant in a criminal case is under no duty to present any evidence tending to prove innocence and is not required to take the stand and testify in the case. If the defendant elects not to testify, no inference, hurtful, harmful, or adverse to the defendant shall be drawn by the jury, nor shall such fact be held against the defendant in any way. A number of statements that the defendants have allegedly made were offered for your consideration. Before you may consider any of these as evidence for any purpose, you must determine whether the individual statements were voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by a defendant offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement, if any, should so you find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by a defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of a defendant beyond any reasonable doubt. Any out-of-court statement made by one of the defendants on trial in this case, after the alleged criminal act has ended, may be considered only against the person who made the statement and only if you find that such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only as against the particular defendant who made it. Now, members of the jury, this court is responsible for determining the admissibility of certain evidence with regard to statements in this case. Sometimes full audio and/or video recordings cannot be played for you for legal reasons. You are not to make any inferences for or against either party in the case about the fact that the law does not allow the playing of certain recordings by the parties in this case. Now, evidence of prior difficulties or lack thereof between one or more of the defendants and Mr. Arbery has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendants and Mr. Arbery, and the reasonableness of any alleged fears by the defendants or Mr. Arbery. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine. But you are not to consider such evidence for any other purposes. Certain evidence of fingerprint comparison has been admitted by the court for your possible consideration. Identification by fingerprint comparison is opinion evidence and is dependent upon the credibility or believability and accuracy of the expert witness called for that purpose, as well as the following factors. 1, the validity of the theory of identification by fingerprint comparison. 2, the credibility of the witness who performs other necessary functions in making the comparison, such as inked finger impressions and latent lifts. And 3, the accuracy of procedures in identifying, preserving, recording, and maintaining integrity of the physical evidence, all of which are questions for the jury. Now, the defendants are charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by the statute. The defendants will not be presumed to have acted with criminal intent, but you may find such an intention upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused are being prosecuted. Now, every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of a defendant that a crime was being committed and that a defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that a defendant had no knowledge that a crime was being committed, or that a defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit that defendant. On the other hand, should you find beyond a reasonable doubt that a defendant had knowledge that a crime was being committed and that a defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict that defendant. A person shall not be found guilty of a crime if the act or omission to act constituting the crime was induced by misapprehension of fact that, if true, would have justified the act or omission. Now, the law provides that criminal action shall be tried in the county where the crime was committed. Venue, that is, that the crime was committed in Glenn County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. The defendants are charged with the offenses of malice murder, felony murder in 4 counts, aggravated assault 2 counts, and false imprisonment and criminal attempt to commit a felony. I will now define the offenses for you. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that a defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If the killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in a defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in a defendant's mind at the time of the act or the killing, and moved a defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining a defendant's state of mind at the time of the killing. A person also commits the crime of felony murder when, in the commission of a felony, that person causes the death of another human being. Under the laws of Georgia, aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment are all felonies that will be defined later in this charge. You may find a defendant guilty of felony murder if you believe that he caused the death of another person by committing one of the felonies just described, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. A person commits the offense of aggravated assault when that person assaults another person with a deadly weapon or with any object, device, or instrument that, when used offensively against a person, is likely to or actually does result in serious bodily injury. To constitute such an assault, actual injury to the alleged victim need not be shown. It is only necessary that the evidence show beyond a reasonable doubt that the defendant attempted to cause a violent injury to the alleged victim or intentionally committed an act that placed the alleged victim in reasonable fear of immediately receiving a violent injury. As to count 6 of the indictment, the state must prove as a material element of aggravated assault, as alleged in this case, that the assault was made with a deadly weapon. As to count 7 of the indictment, the state must prove as a material element of aggravated assault, as alleged in this case, that the assault was made with an object, device, or instrument that, when used offensively against a person, is likely to or does actually result in serious bodily injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. In deciding whether a pickup truck is an offensive weapon in this case, you may consider all of the following factors: the nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, any other circumstances and any other circumstances of the case. Whether or not, under all of the facts and circumstances of this case, a pickup truck, as alleged in this bill of indictment, did in fact constitute a weapon likely to cause serious bodily injury, is a matter to be decided by the jury from the evidence in this case. Now, on count 7, as to defendant William R. Bryan, you may consider the following lesser offenses which will be presented on his verdict form. Simple assault. A person commits simple assault when that person attempts to commit a violent injury to the person of another. Reckless conduct. A person commits reckless conduct when that person endangers the bodily safety of another person by consciously disregarding a substantial and unjustifiable risk that his act or omission will cause harm or endanger the safety of another person, and the disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in the situation. And reckless driving. A person commits the offense of reckless driving by driving any vehicle in reckless disregard for the safety of persons or property. If you do not believe beyond a reasonable doubt that the defendant William R. Bryan is guilty of aggravated assault as alleged in count 7 of the indictment, but you do believe beyond a reasonable doubt that the defendant William R. Bryan is guilty of the lesser offenses just listed, you would be authorized to find the defendant William R. Bryan guilty of the lesser and should so indicate on the verdict form. Continuing now with the charges set forth in the indictment. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. A person commits criminal attempt to commit false imprisonment when, with intent to commit false imprisonment, that person performs any act that constitutes a substantial step toward the commission of the crime of false imprisonment, which has been previously defined for you. Now, ladies and gentlemen, I charge you that whereas here in count 7 and 9 of the indictment, the state alleges that the defendants committed a crime in more than one way, the state need not prove that the defendants committed the crime in each way charged. Rather, it is sufficient if you, the jury, should find, beyond a reasonable doubt, that the defendants committed the crime in at least one of the ways alleged. Now, ladies and gentlemen, the defendants have raised a defense that even if they committed the acts described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. The fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. The defense of justification can be claimed, A, when the person's conduct is justified as the use of force in defense of self, or when the person's conduct is reasonable and is performed in the course of making a lawful arrest. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. The terms "in his presence" and "within his immediate knowledge" are synonymous in a crime committed in one's presence only if, by the exercise of any of his senses, he has knowledge of its commission, or by the accused admitting that such a crime is being or has been committed. A private person may not act on the unsupported statement of others alone. A private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of the offense, or during escape in the case of felonies, his power to do so is extinguished. A private person may arrest an offender upon reasonable and probable grounds of suspicion, that is, on probable cause, which is defined as facts and circumstances that are sufficient to warrant a prudent person or one of reasonable caution in believing, in the circumstances shown, that the suspect has committed an offense. The facts necessary to establish probable cause for arrest are much less than those required to prove guilt beyond a reasonable doubt at trial. The test merely requires a probability, less than a certainty, but more than a mere suspicion or possibility. In determining whether probable cause exists, the totality of the circumstances must be considered. Whether probable cause existed is for the determination of the jury. Now, an arrest is defined as the taking, seizing, or detaining of the person of another, either by touching or putting hands on him, or by any act indicating an intention to take such person into custody, and which subjects such person to the actual control and will of the person making the arrest. An arrest can occur even when a subject is not told that he is under arrest. A person is authorized to use, in making a lawful arrest, only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the person the right to use excessive force or an unlawful degree of force upon the person being arrested. One upon whom an illegal or unlawful arrest is being made has the right to resist the arrest if such force as is reasonably necessary. Let me read that again. One upon whom an illegal or unlawful arrest is being made has the right to resist the arrest with such force as is reasonably necessary to prevent the arrest. A person commits the offense of criminal trespass when that person knowingly and without authority, A, enters upon the land or premises of another person for an unlawful purpose. B, enters upon the land or premises of another person after receiving, prior to entry, notice from the owner, rightful occupant, or, upon proper identification, an authorized representative of the owner or rightful occupant that entry is forbidden, or remains upon the land or premises of another person after receiving notice from the owner, rightful occupant, or, upon proper identification, an authorized representative of the owner or rightful occupant to depart. A person commits the offense of burglary in the first degree when, without authority and with the intent to commit a theft therein, that person enters or remains within the dwelling of another. For purposes of this law, a dwelling includes any house, building, or structure which is designed or intended for occupancy for residential use. It makes no difference whether the building or structure was occupied, unoccupied, or vacant. However, you may consider occupation status in determining whether or not the structure in question was designed or intended for residential use. To constitute the offense of burglary, it is not necessary that it be shown that a break-in occurred. To constitute entry, the evidence need only show a breaking of the plane of the structure alleged by the offender, or by any part of his body, or by any instrument controlled by him. The evidence need not show that an actual theft was accomplished. However, an intent to commit a theft, that is, an intent to steal, is an essential element of burglary. You may infer an intent to steal where the evidence shows an unlawful entry without authority into the place of another where items of some value are present or kept inside, and where there is no other apparent motive for the entry. Whether or not you make such an inference is a matter solely for you, the jury, to determine. A person commits the crime of hijacking a motor vehicle in the second degree when such person obtains a motor vehicle from an individual without his or her consent. Now, the defendants have raised affirmative defenses claiming that even if the acts described in the indictment were committed, there are circumstances that justify them. Once an affirmative defense is raised, the state must disprove it beyond a reasonable doubt. The fact that a person's conduct is justified is a defense to prosecution for any crime based on that conduct. The defense of justification can be claimed as self-defense and as citizen's arrest. Sometimes a defendant's threat or use of force is legally justified, so is not a crime. Let me read that again. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in threatening or using force against another when, 1, he reasonably believes that the threat or use of force is necessary, 2, to defend himself or a third person, and 3, against the other person's imminent use of unlawful force. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, he reasonably believes that the use of such force is necessary, 2, to prevent A, death or serious bodily injury to himself or a third person, or B, the commission of a forcible felony, which means a felony that involves the use of force or violence against another. Aggravated assault is again a felony which can occur by use of fists if they are used as an offensive weapon. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide a defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if he provokes the threat or use of force, intending to use that threat or force as an excuse to harm the other person, is committing a felony, aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment are felonies that have been previously defined, or is the unjustified initial aggressor unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. For a defendant's threat or use of force to be justified, 1, the defendant must believe that his threat or use of force is necessary. 2, that belief must be reasonable, that is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts him to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. A defendant is not justified in using excessive force while acting in self-defense. If you decide that a defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. Now, if, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that a defendant in Glynn County, Georgia, did on February 23, 2020, commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that a defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another or all. You, the jury, must determine the guilt or innocence of each defendant separately. You will be given a special verdict form for each defendant to use when you retire. You are to consider each count separately. In the space provided on the verdict form, you will indicate either guilty or not guilty depending on your verdict for that count and that defendant. Now, I want to emphasize that anything the court did or said during the course of this case was not intended to and did not intimate, hint, or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine. And whatever your verdict, it must be agreed upon by all of you. The court's interest in the matter is that the case be fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as the court has instructed you and return a verdict that speaks the truth as you find the truth of the case to be. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to any party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. Now, you are only concerned with the guilt or innocence of each defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson who will manage your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. During deliberations, you must not communicate with anyone other than your fellow jurors about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, I still have BlackBerry in this, computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, MySpace, LinkedIn, YouTube, Twitter, the list goes on and on. You cannot use any of those to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Whatever your verdict is, it must be unanimous, that is, agreed by all, as to each count of the indictment and as to each defendant. Each verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. I do ask whoever the foreperson is, please write in pen. Please don't sign the verdict form in pencil. Now, ladies and gentlemen, you may retire to the jury room, but do not begin your deliberations until you have received the indictment and the evidence that has been admitted in the case. We do need to separate out the three alternates. Three of you are alternates, which we will separate out for deliberations. The three alternates will continue to be jurors in this case and still subject to all of the instructions of the court. If at some point during the proceedings one of the deliberating jurors is not able to complete their duty for the court, then the alternate will be brought into deliberations, and deliberations will begin again with that alternate. So with that, ladies and gentlemen, I ask that you retire to the jury room.
All right for the jury.
All right, beyond matters already raised in the charge conference, any objection to the charge as read from the state?
None, Your Honor.
From Travis McMichael.
Just renewing our previous objections, Your Honor.
Gregory McMichael.
Yes, just renewing the previous objections and exceptions, excuse me, which include the reasonable doubt charge, the one sentence, and then later in the charge, the last sentence of the paragraph concerning the synonymous terms in his presence and within his immediate knowledge, accepted to a private person may not act on the unsupported statements of others alone. And then the entire next paragraph concerning contemporaneity of the offense and the actions of the person making the arrest. And I I believe the court has already indicated that the arguments made by email on Saturday, November 20th, I believe it was, will be put into the record in support of those exceptions.
I'm going to do that with a notice of file for Mr. Bryan.
On behalf of Mr. Bryan, we renew the objections to the charge and exceptions made thereto. And although I don't think it's necessary, we will also renew the many motions for mistrial that were made during the trial of the case.
All right, let's go ahead and check the evidence then. It is this court's practice with firearms not to send out the live ammunition or the weapon itself, and I also don't send out the videos. Normally these days, jurors don't have the ability to play the videos, but given the court's position is if there's a request to replay a video, it needs to be done with all the formalities of the court, and so they can go ahead and request that, but we do that here, so I don't send them out.
Your Honor, do you have the verdict forms? I don't know if I've
And I
seen
do have, if I could have you all take a look at the verdict forms to see if there's any objections to the verdict forms. I also have a copy of the charge that I will give to the clerk as courts 5, I think we're on, which will be courts 5. That will go out to the panel. Go ahead and take a look at that before it goes out also. So I got the verdict form and the charge.
If I could inquire before we end here.
I'm sorry?
If I could inquire before we end.
Good.
Go ahead. Did the court take some more time to think about whether the court would bring the jury in and ask them in front of us if anything has come up? We wanted to see that process happen.
I did. I don't think it's necessary here. Today, there's very few, if any, people out front that I'm aware of. I haven't heard of anything or any issues. Again, last night, the only reason I moved the jury is because after getting permission from counsel to go into the jury room, I had heard, probably not as I was walking in, but I heard as I was talking to the panel something that sounded like a crowd outside, and asked the panel whether or not they heard that, and the response was they just heard that too. And I thought in an abundance of caution, not really knowing what exactly was happening outside, that I'd go ahead and move them into one of the interior courtrooms. That apparently was, there had been movement outside. There was a protest group that was walking around the courthouse. I believe what the court did yesterday was appropriate under the circumstances and actually consistent with some of the requests that have been made by counsel. I did not do it because I felt there was any safety concerns or any other problems. I simply did it in an abundance of caution. I don't want to go into where they are now, but I'm satisfied today there have been no issues whatsoever, and so no, I don't plan on going into that inquiry. But I do recall the request being made. I'm satisfied that there have not been any issues along those lines.
And I guess I would be joining in that. The record is what it is, but I don't believe the court has inquired of the jury affirmatively a single time from their impanelment to this moment. And I don't think it would be inappropriate, given all that has transpired in the public gallery and outside the courthouse in this case, for the court to inquire affirmatively at least once of this jury panel. Having said that, I'm going to sit down.
Let's go ahead and check the evidence. The proposed verdict form should be somewhere in the as well as the, I'm sorry, they're right here. And let's go ahead and do that so we can get the evidence to the panel.
Andrew, I had, and I just want to make sure this is consistent with what everyone else in the court has as the 3 alternates. Currently, I'm going to use their current numbers: 14, 13, and 6.
Mine's, I will find that. I didn't realize you were going to bring that up right now.
Do you have their original numbers?
Next to the current number.
Yep.
Yes. You also want the original numbers? Original numbers. 773. That was for 14. Correct. 364 is number 13. And 440 is number 6.
I believe that.
In addition, I will get with defense counsel about the method that the evidence is in right now, where it is in file folders labeled with the numbers, and we'll go through it.
Okay, that's good. I'm going to stay on the bench until we have all these formalities addressed. So once we know we've got all the evidence together and everybody's had an opportunity to look at the verdict forms, we'll get that addressed.